Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be dealing with all the important questions of the Insolvency and Bankruptcy Code 2016. So apart from the Companies Act, the IBC and LLP, they are also very important. So please make sure when you are preparing for the company laws, you go through these topics as well, right? So we have done the important questions of the LLP in our last lecture and today we will be starting with the IBC, that is the Insolvency and Bankruptcy Code 2016, right? Let's begin. Before I start, I would like to tell you that EduTap has come up with 2 courses for your phase 2 examination. Now that your phase 2 examination has been postponed, you have this opportunity that if you were not preparing for your examination well, you can start preparing now, and if you were preparing really well, then you get even more time to practice and revise, right? So please avail this opportunity that has been given to you now that your exam has been postponed. So please make sure you go through the courses. These courses will be very helpful for you. They will be very helpful for your practicing, for your revision and for understanding your concepts, right? So the first one is the test series. In the test series, you get chapter wise tests. So you get different tests for each and every chapter that has been mentioned in your syllabus, right? For IPC, for CRPC, for companies law, for securities laws, for all the laws that have been mentioned in your syllabus, you get separate test on each of them, right? Another feature of the test series is full length tests. So you get full length tests, you can practice on these tests and you will also be evaluated by our experts. The descriptive portion that has been introduced by SEBI for the first time, it will be very helpful for you if our experts will give you feedback that you will be solving the questions and you will be provided with the necessary feedback, and you also get one-on-one mentor support. Other than that, we also have a live crash course which will be very helpful for you. The unique feature of the live crash course is the live classes. The live classes, they are already been conducted, and the classes which have already been conducted, you can get the recorded sessions for those, right? So this will be very helpful for you, and now that you have time, you can start preparing for these, right? Other than that, you also get short notes. You can take the help of these short notes to form your answers for the descriptive part, which can be evaluated by our experts, right? And all the features of the test series, it has been included in the live crash course, so it will be very helpful for your preparation. And lastly, you get one-on-one mentor support. So if you have any inquiry, any doubt regarding any question, regarding any law, regarding any act, you can ask the mentor and it will be clarified for you, right? So we are running a limited time period offer. Make sure that you avail it because it will be very beneficial for your examination, for your preparation, right? So if you are interested, you can refer to the link in the description below. Now let's start with our lecture. Before diving into the questions, let's understand that what is IBC about? What is IBC? These terms, insolvency, bankruptcy, what are these, right? First of all, let me tell you that IBC, it deals with 3 things: insolvency, bankruptcy and liquidation. You have to understand all these terms. So what is insolvency? Insolvency is the first stage. When your liabilities become more than your assets, then you are said to be insolvent, right? When your liabilities, they become more than your assets and you are unable to pay off your legal debts, then you are said to be what? You are said to be insolvent. This is the first step. What is bankruptcy? Bankruptcy is the legal status you get after being insolvent, right? So you go to the NCLT, the adjudicating authority, you give the application there, and by the NCLT, by the adjudicating authority, you are declared what? You are declared bankrupt, right? So this is the difference between insolvency and bankruptcy. Now there is a third term, that is liquidation. What is liquidation? When insolvency and bankruptcy, they are left untreated, then liquidation happens. Liquidation is the winding up of the company. When in the CIRP process we could not save your company, then liquidation happens, right? So these are the 3 terms which will be used in this code, so you should know about the meaning of these. Now let's start with the questions first. The provisions of IBC apply to any company incorporated under the Companies Act 2013, any limited liability partnership, personal guarantors to the corporate debtors, partnership firms and proprietorship firms. So the answer is E, that is all of the above. IBC deals with the insolvency and bankruptcy of all of these, right? It includes individuals, LLP, partnership firm, company. So all of these, they are correct. Let's read this section. Section number 2, application. The provisions of this code shall apply to any company incorporated under the Companies Act 2013 or under any previous company law, any other company governed by any special act for the time being in force, except in so far as the said provisions are inconsistent with the provisions of such special act. Any limited liability partnership incorporated under the Limited Liability Partnership Act 2008, such other body incorporated under any law for the time being in force as the central government may by notification specify in this behalf, the personal guarantors to the corporate debtors, partnership firm and proprietorship firm, and individual other than the persons referred to in clause E. So now I hope that you are aware with where the IBC will apply. IBC applies to all of these, right? Moving on, question number 2. Debt has been defined under, the answer is option D, that is 311, right? Now what is debt? Let's take an example. Okay, there is a company, let's say A Limited. It goes and applies for a loan to a bank. There is a bank and it applies for a loan to the bank, right? Bank gives the loan to the A Limited. Now A Limited is what? A Limited is a corporate, right? A Limited is a corporate, and at the same time it is a debtor because it has debt due to the bank, right? Now it is a debtor. So now collectively we will call it what? We will be calling it corporate debtor. So A Limited here is what? It is a corporate debtor. Now the bank is the creditor because it has given you credit. He is what? It is what? It is a creditor, right? Now A Limited, it is a corporate debtor, and the bank is what? Bank is the creditor. Now A has a debt towards bank, right? A Limited, it has a debt towards the bank, and bank has what? Bank has a claim. It has a right to payment. It has a claim towards A Limited, right? So now you so I hope now you are somewhat clear about these terms. Let's understand debt. Debt means a liability or obligation in respect of a claim. Now the bank, it has a claim, and the debt is what? Debt is the right or an obligation that is imposed due to that claim, right? So debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and an operational debt. Question number 3. As per section 3 of IBC Act, claim means, the answer is D, that is both A and B. It is a right to payment and right to remedy for breach of contract under any law for the time being in force if such breach gives rise to the right of payment. So what is a claim? First I have told you that it is a right to payment, right? So it is a right to payment whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. And secondly, right to remedy for a breach of contract under any law for the time being in force if such breach gives rise to a right to payment. Now what does this mean? For example, there is a contract, and under the conditions of the contract it has been mentioned that the party who breaches it, the other party is going to be liable for what? It will be liable for compensation. And in case of a breach now that you are liable for to get compensation, in that case this compensation, this right to get compensated, this is what? This is also your claim, right? So rights to remedy for the breach of contract under any law for the time being in force if such breach gives rise to the right to payment whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. So now I hope you are clear with these terms, right? Moving on, question number 4. Which of the following is not a creditor as per section 3 of IBC? The answer is E, that is judgment debtor is not a creditor, right? Now I have told you that who is a creditor. I have just told you that the person, the bank who gave you the credit, that was the creditor. So means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, unsecured creditor and a decree holder. Now you should understand that what is the difference between financial creditor and an operational creditor, right? So in the same example where A Limited, it applied for a loan from the bank. Here in this situation the bank was a financial creditor. Why? Because it gave you credit. It gave you what? It gave you the credit directly. So it was what? It was a financial creditor. But on the other hand, what is an operational creditor? Operational creditor is someone who has given you some kind of service. It has not given you credit. It has given you some kind of service, and the payment is due to him. For example, let's just say that A Limited has not paid the salary of its employees for 1 year. In this case, the employees are what? Here the employees are what? Employees are the operational creditors, right? We can take another example. For example, A Limited, it has not paid its taxes to the government, right? It has not paid taxes. In this case also, the government becomes what? It becomes operational creditor. Or let's just say that there is another company that has supplied some goods or some raw material to A Limited. In this case also, if A Limited does not pay to them, they are what? They are termed. They will be what? They will be termed as operational creditor. So now I hope you are clear with all these terms. The corporate debtor, debt, claim, financial creditor, operational creditor, right? So these are the terms that will be used in the code. Alright, moving on, question number 5. What is the impact of IBC on other legislation? The answer is C. IBC has an overriding effect on other legislations, right? So what does that mean? That if there is an inconsistency between another law and IBC which is going to prevail, the IBC is going to prevail. So the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or in instrument having effect by the virtue of such law. Question number 6. Who can initiate corporate insolvency resolution process? So now we will be dealing with the CIRP. What is CIRP? How this process goes on, right? So this is important. The answer to this is financial creditor, operational creditor and corporate debtor. So now what is happening here? Let's just continue with our example. So A Limited, it owes debt towards the bank. Now it has made default. It has made default in the payment of the loan, and the financial creditor, it does what? It takes A Limited to NCLT, that is the adjudicating authority here. It takes A Limited to the NCLT and it applies for the CIRP process, the initiation of the CIRP process. It asks the court that A Limited has made a default in the payment of my loan, that A Limited has made this default and I want to start what? I want to start this process because I want my payment back, right? So now in this case, the financial creditor, it is taking the A Limited to the NCLT for the adjudication. But who are the other persons who can initiate this process? There are the operational creditor can also do so, and the corporate debtor himself can also move an application to the NCLT that I want to start this process, right? So who are the persons who can initiate this procedure, who can initiate this process? The financial creditor, the operational creditor and the corporate debtor himself, that is the A Limited himself, right? So where any corporate debtor commits a default, a financial creditor, operational creditor or corporate debtor itself may initiate corporate insolvency resolution process in respect of such corporate debtor in the manner as provided under this chapter. So now I will be telling you that what this process actually is, what are the stages, what are the different stages in this process as we move on with the questions. Alright, question number 7. Which of the following activities shall not be prohibited or terminated during the moratorium period? Now let's understand this process. First of all, what has happened? The financial creditor, the operational creditor or the debtor himself, he has moved an application to the NCLT that I want to start this process, right? Now what happens is NCLT, it admits the application within 14 days, right? Once the application is admitted, the first thing that the NCLT will do is declare the moratorium period. Now what is a moratorium period? Moratorium period is basically the cooling time. It is a cooling period where no activity can take place, which means that no new case can be initiated against A Limited. If another case is pending, it will be halted. No assets of the A Limited can be sold off, right? So this is basically a cooling period. This is declared by the NCLT that the CIRP process is being initiated against the A Limited, and all these procedures, they will be what? They will be prohibited. But which are the things which are not terminated? Let's understand that. The answer is option D, that is the supply of essential goods or services to the corporate debtor. So this is one thing which will not be terminated because if the CIRP process is initiated against a corporate debtor, in that case, that does not mean that their day-to-day functions, they are prohibited, right? The day-to-day functions, they carry on. So basically the supply of essential goods and services, they will not be prohibited. What are these essential goods and services? For example, the electricity supply, the water supply, these will not be terminated, right? So let's understand. Subject to the provisions of subsection 2 and 3 on the insolvency commencement date. Which will be the insolvency commencement date? It will be the date on which the NCLT has admitted the application, either of the financial creditor or the operational creditor or the corporate debtor itself, right? So subject to the provisions of subsection 2 and 3 on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following things, namely the institution of suits or continuation of pending suits. So no new case can be initiated, and if a case is pending, then its proceedings will also be stopped. So the institution of suits or continuation of the pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority. Transferring, alienating or disposing of by the corporate debtor any of his assets or any legal right or beneficial interest therein. Any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of its property, including any action under the SEBI Act 2002, the recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. So the owner cannot even take back the possession if the possession is with the corporate debtor. So these are all the things which are prohibited, but the essential supply of goods and services, they are not stopped during this process, right? Alright, moving on, question number 8. Who constitutes the committee of creditors? Okay, before moving on to the committee of creditors, let's understand that what happens after the moratorium period. So once the moratorium period is declared, the second thing that happens is it is the appointment of the IRP. What is IRP? Interim Resolution Professional. Basically, when the financial creditor or the corporate debtor, when it files the application to NCLT for the initiation of the CIRP process, there it is mandatory for them to give the name of a person, a resolution professional, to recommend the name of a resolution professional to the NCLT, right? In both these cases, the financial creditor and the corporate debtor giving the name of the resolution professional, this is mandatory. But in the case of operational creditor, it is not mandatory, it is discretionary. If they have the name of this person, they can give it to the NCLT. If don't, then in that case the NCLT will appoint the IRP for them. So now where the name of the IRP is provided, in that case it is the NCLT, it is going to satisfy itself that this professional meets with all the conditions, such as does not have any disciplinary proceedings going on against him and all such matters. And if the NCLT is satisfied, then this professional will be appointed as what? It will be appointed as the IRP, that is the interim resolution professional. Now the first thing that the interim resolution professional does is it makes a public announcement. In this public announcement, it declares that CIRP process has been initiated against this company, let's say A Limited, and now if any person has any claim against this company, then it can file this claim to me. They can give this claim to me. Once all these claims, they are consolidated by this resolution professional, the interim resolution professional, he has to do what? He has to separate the financial creditors and the operational creditors. Now the first thing he does is separate the creditors, that is the operational and the financial creditors. But why are we separating them? Because after this a committee is made called the creditors committee, called the committee of creditors, and in this committee only the financial creditors are given the right to vote. Committee, only the financial creditors have a seat, right? Only the financial creditors. This committee includes only the financial creditors. So now unless this committee is constituted, unless then the management and the control of the A Limited is with the IRP. And once this committee is constituted, now the management and the control, it goes to who? It goes to these creditors, and now they will decide the fate. They will decide the fate and it will be validated by the NCLT. Now let's read this. Who constitutes the committee of creditors? Now you know that who constitutes it. Section 21 provides that the interim resolution professional shall, after collation of all the claims received against the corporate debtor and determination of the financial position of the corporate debtor, constitute a committee of creditors. So who constitutes it? It is the IRP, right? Moving on, question number 9. The resolution professional shall give notice of each meeting of the committee of creditors to. Alright, so once a committee of creditors is constituted, the first thing that the committee of creditors do is they appoint the interim resolution professional as the resolution professional. Either they can continue with the same resolution professional and they can appoint the IRP as resolution professional, or they can change him also. So the first business they do is what? They first appoint the resolution professional, and now the term of the interim resolution professional, it ceases, and now the resolution professional comes into picture, right? So the question is, the resolution professional shall give notice of each meeting of the committee of creditors to. The committee of creditors includes only the financial creditors, but if a meeting is conducted, so who all will be given notice of that meeting? Let's find out. The answer is C, members of committee of creditors, member of suspended board of directors and operational creditors in case their aggregate due is not less than 10% of the debt. Let's understand this section. This is section number 24. The members of the committee of creditors may meet in person or by such electronic means as may be specified. All meetings of the committee of creditors shall be conducted by the resolution professional. So this will be conducted by whom? The resolution professional. The resolution professional shall give notice of each meeting to the committee of creditors to members of the committee of creditors, including the authorized representatives referred to in subsection 6 and 6A of section 21. So the members of the committee, they will be given what? They will be given this notice, and their representatives as well. Members of the suspended board of directors, they are talking about A Limited, right? So A Limited's suspended board of directors, they will be given notice, or the partners if it is a partnership firm, or corporate person as the case may be. Operational creditors or their representatives. Operational creditors will also attend this meeting, right? So operational creditors or their representatives, if the amount of their aggregate due is not less than 10% of the debt. So if the operational creditors, if including all the operational creditors, if their debt is not less than 10%, in that case operational creditors will also be given the notice of this meeting, right? So if including all the operational creditors, their debt is not less than 10%, in that case they will also be given that notice. Alright, question number 10. What is the time limit of the completion of the insolvency resolution process? So the answer to this question is C, that is 180 days from the date of the admission of the application. Time limit. Subject to the subsection 2, the corporate insolvency resolution process shall be completed within a period of 180 days from the date of the admission of the application to initiate such process. The resolution professional shall file an application to the adjudicating authority to extend the period of the corporate insolvency resolution process beyond 180 days if instructed to do so by resolution passed at a meeting of the committee of creditors by a vote of 66% of the voting shares. So this CIRP process, it has to be completed within 180 days. But another 90 days period, not more than 90 days period, it can be given if the resolution is passed by the committee of creditors by 66%, right? On receipt of an application under subsection 2, if the adjudicating authority is satisfied that the subject matter of the case is such that the corporate insolvency resolution process cannot be completed within 180 days, it may by order extend the duration of such process beyond 180 days by such further period as is things fit, but not exceeding 90 days. So another time period of 90 days, not exceeding 90 days, it can be given, and it can be given only once, right? So it can be extended only once, and maximum of 90 days can be given, provided that any extension of the period of the corporate insolvency resolution process under this section shall not be granted more than once. Provided further that the corporate insolvency resolution process shall mandatorily be completed within a period of 330 days from the insolvency commencement date, including any extension on the period of the corporate insolvency resolution process granted under this section and the time taken in legal proceedings in relation to such resolution process of the corporate debtor. So basically this process, it has to be completed within 180 days. 90 days can be given if they want to extend it. But this 330 days includes what? It includes if, for example, any legal proceeding, any appeal is pending. If, for example, A Limited files any appeal, then all of these pending appeals, all of the legal proceedings has to be completed within what? Within 330 days. So more than 330 days, they cannot be taken, right? So you have to remember that 180 days, 90 days, and in total 330 days. Alright, moving on, question number 11. How many days from the day of delivery of the notice or invoice demanding the payment, the operational creditor may file an application before the adjudicating authority for initiating a corporate insolvency resolution process if does not receive payment from the corporate debtor or notice of the dispute? The answer to this question is B, that is within 10 days. Okay, so now let's understand that what is happening here. Let's continue with our example. If A Limited has made the default in the payment of a financial creditor in in that case the financial creditor does not have to wait for anything. On the day of such default, it can do what? It can file the application to the NCLT to start the CIRP process. But in case of operational creditor, the procedure is a little different. In case of operational creditor, what happens is operational creditor has to send a notice to A Limited first. It has to send a notice, a demand notice or an invoice demanding the payment that is due to him, right? Now what happens is either A Limited is going to make the payment within 10 days or it is going to give notice about any dispute that has arisen between them. What can be the dispute? For example, that A Limited found that the raw material that was supplied to it is not of good quality, it is not the quality which was agreed upon. In that case, now A Limited can do what? It can send the notice to the company, to that operational creditor, stating that dispute, it has to be done within 10 days. If any such dispute is arising, in that case they have to first solve that dispute among themselves, and if after that still any claim is remaining, in that case they can move to the NCLT to start the CIRP process. Now, but let's just say that A Limited, it did not give any notice or it did not make the payment within these 10 days that were given. Now in that case, what can the operational creditor do? The operational creditor can now, after the completion of these 10 days, move to the NCLT with this application, right? So this is why the answer is B, that is 10 days. After the expiry of the period of 10 days from the date of the delivery of the notice or the invoice demanding payment under subsection 1 of the section 8, if the operational creditor does not receive payment from the corporate debtor or notice of the dispute under subsection 2 of section 8, the operational creditor may file an application before the adjudicating authority for initiating a corporate insolvency resolution process. Alright, moving on, question number 12. Under section 10, within how many days adjudicating authority has to admit the application or reject the application? This we have done. The answer is 14 days. The adjudicating authority shall, within a period of 14 days of the receipt of the application by an order, admit the application if it is complete and no disciplinary proceeding is pending against the proposed resolution professional, so the name that was provided by the creditor. Reject the application if it is incomplete or any disciplinary proceeding is pending against the proposed resolution professional, provided that the adjudicating authority shall, before rejecting the application, give a notice to the applicant to rectify the defects in his application within 7 days from the date of receipt of the notice from the adjudicating authority. In case there is a mistake that can be rectified, for that rectification 7 days will be given to the applicant. Alright, moving on, question number 13. The term of the interim resolution professional shall, this also we have done, continue till the date of the appointment of the resolution professional. So the adjudicating authority shall appoint an interim resolution professional on the insolvency commencement date, where the application of the corporate insolvency resolution process is made by the financial creditor or the corporate debtor, as the case may be. The resolution professional, as proposed respectively in the application under section 7 and 10, shall be appointed as the interim resolution professional if no disciplinary proceedings are pending against him. I have told you that in case of the financial creditor and the corporate debtor, it is mandatory for them to provide with this name, and if no disciplinary proceedings are going against him, in that case he will be appointed as the IRP, right? But where the application of the corporate insolvency resolution process is made by the operational creditor and no proposal for an interim resolution professional is made, the adjudicating authority shall make reference to the board being the IBBI, that is the Insolvency Bankruptcy Board of India, for the recommendation of an insolvency professional who may act as an interim resolution professional. So if no name has been provided by the operational creditor, in that case the name will be provided by who? We will make, the NCLT will make an application to the IBBI, that is the board, and it will provide you with an interim resolution professional. A proposal for an interim resolution professional is made under subsection 4 of section 9. The creditor has given you the name. The resolution professional as proposed shall be appointed as the interim resolution professional if no disciplinary proceedings are pending against him. The board shall, within 10 days of the receipt of the reference from the adjudicating authority under subsection 3, recommend the name of the insolvency resolution professional to the adjudicating authority against whom no disciplinary proceedings are pending. So the board within 10 days is going to recommend the name for the IRP. The term of the interim resolution professional shall continue till the date of the appointment of the resolution professional under section 22. This we have already done. And who appoints the resolution professional? It is the committee of creditors. Alright, moving on, question number 14. All decisions of the committee of the creditors shall be taken by, the answer is D, that is 51% of the voting share of the financial creditors. Section 21(8) states that all decisions of the committee of the creditors shall be taken by a vote of not less than 51% of the voting share of the financial creditors. So now let's continue with the process. What is going to happen? Now basically what is going to happen is that once the resolution professional, he has been appointed, now he is going to prepare an information memorandum in which he is going to mention each and every detail of A Limited. He is going to mention everything, their liability, their assets, and everything that is important in this matter. And now he is going to publish this information memorandum. Now what happens is that if any company is interested in acquiring A Limited, right, if it wants to acquire A Limited, in that case it can do what? It can come with a resolution plan. It is called the resolution plan of resolving the insolvency, right? The main focus will be how this new company is going to resolve their insolvency. Let's just say that there comes a company that is C Limited. C Limited, it brings a resolution plan. This resolution plan is passed by the RP. Okay? Then after that it is passed by the committee of creditors, and after passing by the committee of creditors, it is passed by the NCLT as well. In that case, now C will acquire A Limited. C Limited is going to acquire A Limited, and we will say what? We will say that this CIRP process has been successful, right? So now this the insolvency process, it has been successful, and now the company is under who? The company is under the C Limited. And all this process, including the coming of C Limited, giving the resolution plan, and it being passed by the committee of creditors, the NCLT, all this has to be done within what? Within 180 days, as we have read, and it can be extended to 90 days as well. So this is the CIRP process that takes place. I hope you are clear with this. But now let's just say that CIRP process could not be successful. In that case, what is going to happen? There could be reasons such as, for example, no one wanted to acquire A Limited, or the resolution plans that came, they were not passed by the creditors, they were not good enough for them. Now in that case, what is going to happen? The liquidation. That is the winding up of the company, right? Alright, moving on, last question. Where the adjudicating authority rejects the resolution plan under section 31 for the non-compliance of the requirements specified therein, it shall. The answer is option E, A, B and C. Let's read this section only. So where the adjudicating authority, before the expiry of the insolvency resolution process or the maximum period permitted for the completion of the corporate insolvency resolution process under section 12, or the fast track corporate insolvency resolution process under section 56, as the case may be, does not receive a resolution plan. If it does not receive a resolution plan or rejects the resolution plan under section 31 for the non-compliance of the requirements specified therein, it shall pass an order requiring the corporate debtor to be liquidated in the manner as laid down in this chapter. In that case, now what will happen? An order of liquidation is going to be passed. Issue a public announcement stating that the corporate debtor is in liquidation, and require such order to be sent to the authority with which the corporate debtor is registered. So now the liquidation proceedings, the liquidation process is going to be initiated against the A Limited, right? Alright, so now question for achievers. Any person aggrieved by an order of the NCLT may file an appeal to the Supreme Court on a question of law arising out of such order under this code within. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.